Welcome to the Taxpayer Podcast, a podcast production by the Taxpayer. For more informative discussion on tax law, please visit our website to learn more about the Taxpayer Journal.
Hello, Peter. Nice to see you again.
Hi, Trevor. You too.
We seem to be squeezing a podcast in just before the end of April.
Yeah, it's taken too long. I look a bit guilty, but
It's taken far too long. Yeah. The garrulousness is willing, but we just sometimes we're also busy people. Today we're going to discuss the Polter case, which is a decision of a full bench of the Western Cape Division of the High Court, Judge Binsward giving the judgment, and concurred in by Judges Nuku and Slingers. And I suspect that this is Judge Binsward's very last judgment, because I think he's just retired. And boy, has he gone out on a note of controversy, in my opinion. So the facts were, there have been a number of cases, and I quite frankly haven't followed them terribly much, involving a taxpayer by the surname of van der Merwe, and her father represented her considerably throughout. And there have been various cases. And this is an appeal from a judgment of the tax court in respect of the daughter's 2018 year of assessment. She's changed her surname to Polter, so the case name is Candace Jean Polter versus Commissioner for Inland Revenue. And what happened was she didn't appear at the tax court, and she was the taxpayer, but her father appeared to represent her, and the tax court held that her father didn't have right of appearance in the tax court, and therefore dismissed the appeal with costs on an attorney and client scale, so that's punitive costs, and for two counsel. And that was taken on appeal, and a colleague of mine at the bar, who rejoices in the nickname Par 3, I don't know if you know who I'm referring to, but the case before the bench. And boy, it's given rise to a decision that certainly took me by surprise. Judge Binsward made the point that the Legal Practice Act provides that only persons who are not legal practitioners cannot appear in a court of law, using those words, a court of law, in exchange for consideration or remuneration or anything like that. And Polter's counsel argued that, well, that meant if the person was acting without any reward, then they could appear, and the court dismissed that. But the court then went into a great deal of analysis and taking into consideration a vast array of judicial decisions, both in South Africa, including Harris versus the Minister of Interior's judgment of Judge Schreiner. You remember when they tried to create the Senate as a court of appeal, and also overseas decisions.
Yeah.
And the thrust of those decisions, according to him, was that you assess whether something is a court of law with reference to its function. So what is the function of the tribunal or court? You're trying to decide whether it's a tribunal or a court of law. And he seems, on my reading of the judgment, to have latched onto the fact that the tax court is a court of revision. In other words, the tax court can, and this is not disputed, the tax court can substitute its own decision for that of the commissioner on the facts before it. And he used that to say that the tax court functions as an administrative tribunal, and therefore it's not a court of law. And he also had a look at Section 166 of the Constitution, which defines the courts, and it starts off with, it's characteristically simple and forthright. I'm reading from it now. The courts are A, the Constitutional Court, B, the Supreme Court of Appeal, C, the High Court, and so on. D, the Magistrates Court. And then E, any other court established or recognized in terms of an Act of Parliament, including any other court of a similar status to the High Court or the Magistrates Court. In my opinion, all one needs to look at is paragraph E, any other court established or recognized in terms of an Act of Parliament. Now, the court held that the tax court is established by the president. In other words, the president, not the president of the tax court, but the president of the Republic, currently Cyril Ramaphosa. And he did that on the basis of the following. In section 116 of the Tax Administration Act, it reads as follows. 1. The President of the Republic may, by proclamation in the Gazette, establish a tax court or additional tax courts. If it stopped there, he might have had a point, but then it says 4 areas that the President thinks fit and may abolish an existing tax court as circumstances may. In other words, it's got a geographical component to it. And then subsection 2, the tax court is a court of record. That's not because the president says so, it's because the Act says so. Then in what will appear in the tax court, in the Taxpayer Journal in due course, from sections 117 to 132, all of those provisions deal with the tax court. And just to read some of the topics, jurisdiction of the court. Section 118 is the constitution of the tax court, which in terms refers to a tax court established under this Act. But the full bench doesn't regard it as being established under this Act. It regards as being established by the president. With respect, I think they're wrong on that point. So
Just on that, Trevor, if I can come in there, because at the court, I think they held that on a literal basis, it is a court recognized in terms of an Act of Parliament. So really, they're a little bit on the back foot where they say, on a literal reading, it is a court recognized in terms of an Act of Parliament, i.e. the TAA. And now you have to back solve why, if that's the literal interpretation, you have to go to, where do you go to? Some kind of language or context or something to kind of read out of that literal interpretation. I think it's more than a literal interpretation. It's a proper interpretation. And the court seemed to concede that. And then they went on to say, however, that's insufficient to answer the question whether it constitutes a court of law. Well, why is it insufficient?
Well, because
it's clearly stated.
What they're saying is, was it intended to be a court? No, why would you call it? It says not every tribunal which is called a court is in fact a court, even if it's required to act judicially. But I think the tax court very much is a court. And if I can read a passage from the judgment, which I think throws a certain light on this as well. The full bench says that it's very unusual in a tax case to have only a point of law in dispute. Now, my experience, and I'm not saying I'm as experienced as the members of the court, but I do have some experience. In my experience, tax cases often have disputes of law only. And throughout the many years that I lectured at UCT, half of my class was often accountants and therefore not lawyers. And if a non-lawyer thinks about litigation and a court case, and that many of them think of O.J. Simpson or Oscar Pistorius, they think of a criminal trial. I always used to say to them, the difference between a criminal trial and a tax case is as follows. In a criminal trial, mostly we know what the law is. We know what murder is. It's the intentional killing of another human being and dolus. We know what theft is and robbery and all of that stuff. What the case is about is trying to discover the facts. Did the person do it or did the person not do? So we know the law, but we're trying to establish the facts. In a tax case, it's very often exactly the opposite. We know what the facts are. The problem is we don't know what the law is. And I always used to say to them, that's why I find tax law so interesting, because we have to still discover what it is. Of course, there are many cases where there are disputes of fact, because the taxpayer bears the burden of proof, and it becomes a tactical thing that SARS will put the taxpayer to the proof. So you have to call a witness and you have to establish the facts. But by and large, very often we know what the facts are. And two recent cases, the Big G restaurants case, which went to the Constitutional Court, case involving Section 24C, allowance for future expenditure. There was no statement of agreed facts in that case. The Thistle Trust case, which was heard in the Constitutional Court on the 8th of February, and we're awaiting judgment right now, there was a statement of agreed fact. And the law reports are riddled with examples of it. So the court can say that that's not the case. Beats me. I think they're trying to minimize the role of deciding legal principles, which is characteristic of a court. But of course, you know, that's what tax courts do all the time. They decide, even SARS does that. You know, SARS, if deciding whether an amount's capital or revenue, they're applying the law. But a tax court does it decisively. And interestingly enough, Binswaard himself was the judge who gave the judgment in the South Atlantic Jazz Festival case, and also in Forge Packaging. And in both of those cases, he held that the tax court has powers of review, obviously related to the assessment that's being appealed. But how can a purely administrative tribunal have powers of review? So yes, there are features about the tax court which make it unique, in that it is a court of revision. It can substitute its own decision for that of powers, but I see those as being additional powers, not as being their only powers. And that tax court all the time does exactly what other courts of law do. They don't have an inherent jurisdiction, but
also they have, as you say, the president of the tax court is also a high court judge, you know, sitting with two assessors. And again, the assessors give additional weight to the court, calling it a court, as opposed to reducing its powers. And I agree with you, Trevor, that it often deals with very complicated issues of law, questions of law. Tax law, we've said many times, is complex. The legal questions are complex, and the facts, as you say, are often quite simple. And you know, the court here said that the tax court has a narrowly defined jurisdiction, which on substantive matters is to ultimately determine a taxpayer's liability for assessed taxes. So the fact that it has a limited jurisdiction doesn't mean that it's not a court of law. You know, I don't see how that connection is made. And as you say, they end up with a conclusion, what they're reading a bit here. The characteristics of the tax court impel the conclusion that its function is essentially that of an administrative tribunal. As you said, Trevor, to me, there'd be many judges and presidents of the tax court who'd be very surprised to hear that they were part of an administrative tribunal as opposed to a court. You know, and the fact that it's been established as a court and is required to discharge its functions in a judicial manner, they say, do not negate its role essentially as an administrative decision maker. And that's not what I thought the tax court does.
I just think that's wrong. And as far as matters of law, Section 118.3 of the Tax Administration Act says, if an appeal to the tax court involves a matter of law only, or is an interlocutory application, etc., the president of the court sitting alone must decide the appeal. That shows you that it's quite common.
Yes, exactly.
I really think they're barking up the wrong tree. Now, having said all that, personally, I've got no problem with tax practitioners or accountants appearing in the tax court. It was for years and years, and for decades it was the case, and I don't think the law suffered as a result. My only gripe with this decision is the finding that the tax court is not a court of law. I mean, the tax court, if the amount involved is more than 50 million rand, it can be constituted with 3 judges. And you mean to tell me that's not a court of law? Really, what is it? It's a very high-powered administrative tribunal, if that's what it is. You know, I don't know. I think Judge Binswaard has gone out and it's a very respectable judgment in the sense that it's well researched and it's articulated well and all of that. I just happen to disagree.
And I agree with you on that, Trevor. And as you say, you know, it's just, I think, a wrong conclusion. I think the tax court is a court of law. As you say, what turns on it? The fact that lay people can appear in the tax court. it'll be interesting to see if that does happen and to what extent that happens. I've certainly heard it said, and I agree that if you're not a seasoned tax litigator like yourself, Trevor, and there are only a handful around, you'd be very brave to appear in the tax court, especially if you're up against a proper tax litigator like yourself, Trevor, without knowing the relevant rules, without knowing how to, argue, without knowing how to cross-examine. And all of those skills are what you require in a court of law, which it's kind of circular because I think it is a court of law, you'd be quite brave to appear in what I think is a court of law if you don't have the relevant skills and litigation skills, and in particular as an advocate. If you're appearing in front of an administrative tribunal, you might be a bit braver. And there are a couple of people who've appeared in the tax court who weren't years ago, as you say, who did it successfully, but there are quite a few who did it fairly unsuccessfully for their clients as well. For example, don't expect to see me there anytime soon.
I'm sure you do very well. But also the environment has changed because the tax court now has its own rules. And and if there's a rule that doesn't fit, you can incorporate the High Court rules. So
That's
why
true.
is it so dissimilar from the High Court?
Yeah.
I think we've made the point. I doubt whether this will stay as it is. I don't know whether SARS would appeal it or not. But certainly they could amend the Act, because the Tax Administration Act previously did say that the taxpayer's representative can appear, and they deleted that. But the court quotes the explanatory memorandum saying that it wasn't intended to change the position.
I don't think they'll let it lie. I think, SARS, I think they either will appeal or there'll be a change to the law just to make it clear that the tax court is established by the TAA and not by the president of the country. And that you'd think is, I don't even think there's clarification required, but if there is, I suppose one could clarify that judicially, or through legislation.
Okay, so I'm glad that we agree. We hadn't discussed this beforehand, so I'm not scared of disagreement, because often disagreeing with the full bench. But it's nice to agree with you, Peter. Now you've got something else in store.
I do. I want to tell you about a couple of pillars, 2 pillars, in fact. And with international tax law, there's so much jargon around. So the first thing you have to do is to de-jargonize everything, and then to give a little bit of context. So just by way of context, the first bit of jargon, BEPS.
Can I interrupt you? I know no one better equipped to de-jargonize international tax. You are the person who said there's no such thing as international tax law.
That is true. Subject for another day. So BEPS is base erosion profit shifting, and those rules came about, or that all started in 2015. And in fact, one of our editors, Dennis Davis, chaired a commission, and there were lots of input around the globe on base erosion, profit shifting, what's wrong, what's right, what should be allowed, what shouldn't be allowed. And there were a whole lot of action plans that came out of the OECD as a consequence of the BEPS initiative. What those action plans did not deal with was e-commerce, electronic transactions, and in particular the big tech companies, if one sort of cuts through it. And so what happened was quite interesting from an international tax perspective. The big tech companies like the Facebooks and the Amazons and they all based in the USA, and they're all tax resident in the USA. And because they don't operate through a permanent establishment, a traditional permanent establishment, bricks and mortar in particular jurisdictions, source jurisdictions, those source jurisdictions didn't have the right to tax them. So America had the right to tax all of their profits. And despite the fact that they had many, many users globally. So certain countries started imposing on a unilateral basis digital services taxes. And this really irritated the Americans. So the Americans said, we've got to deal with this on a harmonized way. So they came up with what was called Pillar 1. And Pillar 1 basically is a profit allocation and nexus rule. And it basically allocates certain amounts of taxable income to what are called market jurisdictions, regardless of bricks and mortar. It's just where the customers and users are located. which kind of makes sense in a modern world. The problem was, of course, it's hard to get consensus around these rules. So even though they only apply and only kick in to companies with turnovers of exceeding 20 billion euros, so obviously aimed right at the top level of sort of the tech companies, they still haven't been implemented yet. So the idea is that Pillar 1 is going to allocate taxing rights to places where the customers and users are located and not exclusively to America. But the rules have not yet come into force. Those rules have not yet come into force. So that's Pillar 1.
Is America part of that decision?
America's part of that.
Okay.
And that's why it's just dragged on endlessly, and it just has no, it's just not being finalized. And so you are getting to, it's quite interesting because, especially in Africa, with it doesn't necessarily always buy into sort of, the OECD kind of your complexity, if I can put it that way. Just started saying, what a digital services tax, like a VAT or something like that, is actually much more effective. You can impose it unilaterally. You can collect some tax, and you don't have to wait for these so-called developed countries to get their act together and to pass law. So that's happening. We're seeing that a bit more through Africa. They just say, well, hang the Pillar 1, we're going to impose our own digital services taxes and collect some revenue in that way. But so Pillar 1 is still waiting for implementation. Pillar 2 is what a lot of people are talking about at the moment, and that's the global minimum tax. And a lot of people would have heard about this 15% global minimum tax rate. And that, interestingly, has come into effect very, very quickly. So I'll come on to the effective dates in a minute, but the idea is that income should always be taxed at a rate of at least 15%. And the concept is quite simple and quite pure. It's that if you have tax havens like the Cayman Islands or whatever, and they tax at 0%, but if the income arising in that jurisdiction is going to be taxed somewhere at 15%, that would incentivize them to say, well, we might as well impose the tax ourselves at 15%, because if it's going to be taxed somewhere, we might as well assert the taxing rights. That's a sort of the simple, sort of logic behind this. And it's there to stop the so-called race to the bottom with competitive tax rates. Ideas like, income is going to be taxed somewhere at 15%, and you can decide where it is. And of course, it's a nice idea, but it's, like all good ideas, when you try and put them into practice, they become extremely complicated.
Can I interject? Maybe the idea of a place where the tax rate is 0 is to get the 0 tax rate. If it's now 15%, you wouldn't go there at all.
And also, there's sovereign right to... What happened to your sovereignty? Your sort of sovereign right to impose tax rate at a 0, 1, 2, 3%, because you're thinking, I don't need the tax revenues, but I need the foreign investment. And again, Trevor, coming back to Africa, there are a lot of African jurisdictions. They're not tax havens, but they have very strong incentives and allowances, and they want foreign investment. They're hungry for foreign investment. So they provide a lot of tax allowances, and this minimum tax is calculated off an effective tax rate. That's dangerous. It's not rate driven, it's effective tax rate. So if you get a lot of allowances and deductions, etc., you can end up with a tax rate of well below 15%. And then effectively those African countries, using them as an example, are giving up the tax rates to a parent company who may well be in a developed country, so-called developed country like Europe and America. So there's sort of an irony for me a little bit there. But
in working out the effective tax rate, do they compare it with the grossing, the turnover?
It's an accounting concept. So the effective tax rate, so you look at the effective tax rate of all they're called constituent entities, which are all sort of legal entities and partnerships and permanent establishments, etc., in a particular jurisdiction. Combine them all together, you use sort of accounting concepts to say, what is your effective tax rate? Make a whole lot of adjustments. It's a complicated computation. Come up with a number, and then you say, does it constitute an effective tax rate of 15%? If the answer is yes, then you leave it alone. If the answer is no, then that country has the right to increase its tax up to 15%. Or if it doesn't do that, then that right shifts to the top parent company in the group. And again, the group is looked at on very much an accounting basis. Shareholding is relevant, but again, a lot of this is accounting driven. So you go to the top entity and say, do you want to tax this top-up tax, the difference between the effective tax rate and 15%? If they say yes, then you're done. If they say no, you go one level down to the next company just below the parent, whatever jurisdiction they're in. You ask them the question, do you want to impose the top-up tax, yes or no? If yes, you're done. If not, you go down the chain again. So it starts at the bottom entity, goes right up to the top entity, and then sort of works its way down. And at some point, you're going to find an entity in a jurisdiction that says, I'll tax the top up. and that's sort of the gist of it. The interesting thing is the speed of it, which has been implemented. The bill came out in South Africa. The bill came out at the same time as the budget. So, at the same time, these globe rules, the Pillar 2 rules were still being digested, giving some indigestion. The draft bill came out. Public comments were due by the end of March, so that time's gone. And the effective date for the implementation of those rules in South Africa is basically years of assessment starting on or after, I think it was 1 Jan this year. So we are effectively already into the law, and it will be passed, if it's assuming the bill's passed, it'll have a retrospective effect, which is all quite interesting. The expectation is that this will result in 8 billion rand of additional revenue for South Africa. So you can see the reason for the haste in introducing it. But
it sounds very unconstitutional to me. But anyway,
it's a retrospective, complex law that has not yet been sort of finalized internationally, and our bill is far from being finalized. The bill is interesting because Parliament doesn't really sit down and work it out. The bill is almost prescribed to you by the OECD. So they kind of say, this is what your domestic law should look like, kind of copy and paste it into your own domestic legislation, get it passed, and off you go. So it seems to be done a huge amount of haste and as I say, a huge amount of complexity. All sounds superficially quite simple, but calculating the effective tax rate and working out what that is, how to make the adjustments, and who has the taxing rights is not an easy, is not an easy sort of process. So that's the Pillar 2. Those are kind of the Pillar 2 provisions that, as I say, unlike Pillar 1, these have arrived. So this is stuff that our listeners and viewers need to pay attention to immediately. If you've got a cross-border group, whether you the bottom of the chain or the top of the chain, the fact that South Africa has implemented these already, I think, is already very relevant. And in terms of where you're looking to set up entities as well, if you are looking to set up entities in like a tax haven, you may well find that there is an unexpected tax consequence. And of course, this sits outside of our controlled foreign company rules. So if a South African company sets up a subsidiary in like a Cayman Islands, South Africa would have the right to tax at the 15% using these Globe 2 rules, regardless of what our controlled foreign company rules say. So even if there is a foreign business establishment, etc., there still will be this additional tax that sits, as I say, outside of the controlled foreign company rules. So very interesting law, and we're all scrambling to sort of get our heads around sort of the detail of it, in particular the calculation aspects of it. As I say, very accounting driven, but it's here already, Trevor, which is
sounds like a recipe for chaos.
It's a recipe for chaos, and
Uh-huh.
it's a good description. You started off the session kind of talking about the complexity of tax law, and it just grows and grows and grows. It's not just domestic law, it's these rules as well that impact on our domestic law. So again, going back to the original point of it, if a tax court is not a court of law and these aren't sort of complex legal issues, then I don't know what is.
Yeah, and no doubt the tax court will have to pronounce upon these things.
That's the point.
Yeah,
that's exactly the point. It'll have to pronounce on them, and probably in quite short order if the law is passed as it's supposed to be and is in effect already. This is already South African law. So very interesting times.
Wow, that is interesting. You'll have to keep us posted because I'm sure there'll be regular developments. It sounds a bit vague.
Definitely. Yeah. It is. And the vagueness is, as I said, doing the computations. And if you have a tax department, it doesn't have the sort of the skills and expertise and the size and scale to kind of do these calculations, it's going to be quite hard, especially if you've got a global group, So I think a lot of our clients are kind of scrambling in terms of trying to start with these calculations. Well, first of all, wrap your head around the law, and then you have to start actually doing calculations and start filling out tax returns. So quite a very daunting, and as I say, sort of imposed on us to an extent by the OECD and sort of their initiatives.
Have to train people at SARS to administer this sort of thing as well.
Absolutely. I mean, that's going to fall straight onto SARS's plate. And as I say, they're expecting to collect, well, the estimate was around 8 billion rand in additional revenues. So this should be a big focus for them. So very interesting times.
I've been trying to remember, and I haven't succeeded, but there's a case, an English case where I think set in Ireland, where the judge says to the barrister, surely the people have heard of something, and it's some very arcane sort of legal concept like an obiter dictum or something like that. And the barrister retorts, "My lord, in County Cork they speak of little else." Put the judge in his place. But yeah, I think certainly I'm completely ignorant of it, and you aren't. But you'll have to educate us, Peter.
Yeah, absolutely. So
since we last spoke, we've got the Constitutional Court's judgment in the Capitec case.
Yeah,
and I think that warrants another podcast.
And some applause for the quality of the judgment. Do you think, Trevor?
Yeah,
I mean,
it was an excellent judgment. But I haven't thought about it further. I still have a question mark over the actual. The court cleared up a lot of grey areas in VAT, which was fantastic. But its ultimate conclusion, I think it went slightly awry, and it took me a while to come to that conclusion. But anyway, we'll discuss that in another.
We've got a topic for the Dachs podcast, which will not be only in 4 months' time.
Indeed, it won't. Yeah.
Thanks, Trevor.
Okay, well, thanks, Peter. I've really learned something this evening, and you put a certain amount of fear into me, because now we'll have to grips with this.
Yeah, absolutely. Thanks, Trevor. Yeah, and chat soon.
Yeah, speak again. Thanks very much.
Bye.
Bye-bye.
The Taxpayer is hosted by the editors of the Taxpayer Journal, Trevor, Emslie, and Peter Dachs. For more information on our journal and other products, please visit our website at taxpayer.co.za. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. Thank you for listening to the Taxpayer Podcast. You can find more episodes on your favorite podcast platform or on our website at taxpayer.co.za. Please like and subscribe on YouTube and rate our podcast on your podcast platform of choice.